Hello, good afternoon. Welcome to our training today. We are going to be talking about guardianships, and we have Allison Schaberg from Consolidated Planning Group and Allison Packard. She's an attorney that she is going to be talking to us about this important topic. But before we start, I will be talking about a little bit of what Partner Resource Network is. My name is Veronica Alvarez, and I'm the Regional 13 Coordinator for Partners Resource Network. Partner Resource Network is the parent training and information center for Texas. We are funded by the Department of Education, specifically the Office of Special Education. We provide free resources and trainings for parents of children with disabilities and self-advocates that we call, young adults with disabilities that we call them self-advocates. Our mission is to empower and support Texas families and individuals impacted with disabilities or special healthcare needs. Who we serve? Again, parents of children with disability and youth with disabilities from the ages of 0 to 26. Partner Resource Network was first founded in 1986, and now we have 4 projects serving parents in all the areas of here in Texas. We have 20 regional coordinators. Myself, I'm in Region 13. I'm in Austin and surrounding area serving parents, but we are all the same. We are all work for Partner Resource Network, the same family. We just Texas is so big, so that's why we have a lot of coordinators across Texas. Our services are free, and we offer parent workshops, youth workshops, webinars, information and referrals, one-on-one technical assistance. We do a lot of supports in our meetings and prepare you guys with IEP clinics. We do once a year a symposium. We also offer parent leadership trainings, youth leadership trainings, and access to social media resources. So for today, your microphone and your video camera is off. So you have questions, please type it in the chat box, and Allison is going to be answering your questions live, or in also we can type some of your some of the responses in the chat box. This webinar is being recorded, and we are going to share it in our Facebook pages in Partner Resource Network. And also Consolidated Planning Group has a YouTube channel, and they have there all our presentation. And at the end of this session, you are going to receive a link with an evaluation about today's training. Please fill that out. It's only take you like 1 or 2 minutes to do it. And it helps us a lot with your feedback to improve, and also to report to a grant and continue giving you guys free trainings and information and all of that. We do not provide CEUs, but we can do a certificate of attendance. If you need one, please type it in the chat box, and I will happy to make that possible and give you one if you need one. Again, my name is Veronica Alvarez, and that's my phone number and my email. Please visit our webpage, www.prmtexas.org. We have a great information, events, fact sheets, all about disabilities and special healthcare needs. So now let me make a co-host. Allison, I'm making you a co-host. And then let me present you guys again if you are just joining in. Today we are going to be talking about guardianships. And we have, again, Allison Schaberg from the Consolidated Planning Group. She's a financial planner. She has a lot of experience working with families with special healthcare needs. She's a founder of the Consolidated Planning Group. She also is a mother of 2 kids with disabilities. So she has a lot of experience working with families. And today we also have Allison Packard. She's an attorney of law, and she specializes in working with families with special healthcare needs. So thank you guys for being here with us today.
Thank you.
Thank you so much. Thanks for joining us today. It's always a pleasure to be back with you, Veronica. So thanks for putting these webinars together, and also a pleasure to be back with Allison. Consolidated Planning Group, we are a holistic special needs planning firm. We're nationally certified as Social Security advisors and members of the Special Needs Planning Academy. And today we are excited to be talking about guardianship. Again, it's an ongoing conversation and topic that becomes top of mind when we have kids that are transitioning and kind of crossing over that age 18. So we are super excited to be here with Allison again. Allison is in the San Antonio area. She's also a parent, so she knows this journey. She eats, sleeps, and breathes it. Is what I say I do, both personally and professionally. So having said that, I would just like to turn everything over to you, Allison.
Okay, great. Well, thank you so much for having me. And this is a topic that is very personal to me. As was mentioned, I have a daughter with special needs, and this issue of whether or not a guardianship is appropriate versus an alternative is not a simple decision for some of us as parents. For other parents, it's very clear one way or another, but for a lot of people, it is sort of a close call. And so I'd love to go through sort of how the guardianship process works and how we make that determination. First of all, when our children hit the age of 18, we get to decide what to do next. As far as this guardianship or no guardianship decision goes. One thing we can always decide to do as parents is just do nothing. Just keep living life and let our kids try to manage for themselves. Kids who are now adults. It's hard to, think of our children with special needs as being adults. And I'm guilty of still calling my daughter a kid, a child, but you get it. So one thing we do is we just say, let's just let them make decisions and see how that goes. That works in some cases. It can be risky in a lot of cases. So another option is to do the guardianship and have a guardian actually appointed to take over decision-making in certain areas. Another option is to do something less restrictive. The guardianship is a court proceeding and it does take away a lot of rights. And so sometimes we look to see if there's something less restrictive, a way that we can step in. So let's go through those. Allison, if you go to the next screen, what a guardianship is, if you'll go one more, Allison. What a guardianship is a court determination of incapacity and the need for an appointment of a guardian. So basically, the guardianship hearing itself will have two parts. The first part is the judge evaluating all the medical evidence to decide if this person does indeed need a guardian. Are they indeed incapacitated? Incapacitation in our Texas court system means that this adult, because of a physical or mental condition, is substantially unable to provide food, clothing, or shelter for themselves or care for their own physical health. So that's the definition of incapacity. So the first part of the hearing is determining that incapacity. And then the second part of the hearing is determining who the right guardian is, who's the right person to step in and make those decisions. Now, I would say, a lot of us, when we read this definition of incapacity, we think, oh, that's definitely my child. And that a lot of us can see that immediately, but we need medical evidence to back this up. It's not just whether or not I think my daughter's incapacitated. I need a doctor licensed in Texas to fill out a form and provide the medical evidence that the judge needs to see. The form in Texas that is used is called a Certificate of Medical Examination. For short, we call it a CME. And on that CME, the physician is going to answer several pages worth of questions and specifically answer, if you can see this screenshot, number 5, is the person who's going to be under the guardianship, we call that person a proposed ward, is the proposed ward able to drive, to vote, to make their own decisions about marriage, to choose where they live? Those kinds of questions, the doctor will say, yes, the person can do this, or no, the person cannot do that. Depending on the answers in that section, that's where we determine whether or not we're asking for a full guardianship, a total guardianship, or a partial guardianship, or a limited guardianship. We call it a guardianship with limited authority. If, for example, the doctor were to say, I really think this person is capable of voting, and this, and the person who's going to be under a guardianship wants to vote, it's possible to retain the right to vote, for example. And so this is going to be tied not only to what you request in your guardianship application, but what does the doctor recommend? So this form is really, really important in these guardianship proceedings. I always tell the parents that I work with, before you give this to the doctor, read it over, make sure you know what the doctor is answering. Because if you feel like your child should keep certain rights, you need to have that discussion with the doctor before he or she fills out this form so that everybody's on the same page.
Allison, we've seen some doctors be reticent to sign these documents in more recent months. And so as a best practice in general, the doctor that should be filling this out is the doctor that has the longest history with the child, right? Or kind of a background, or what happens. I just want you to talk about what happens in an example that you have a physician that doesn't or won't sign this, but it is necessary. Do you just go to another physician, or what happens? Because we've heard this come up several times.
Yeah, that's a great question. The first thing I would say is I would ask myself, and maybe ask the doctor, why are they not comfortable signing this? It might be the doctor thinks a guardianship is not appropriate, that there is a less restrictive alternative. It might be that, your child really doesn't need to have their rights taken away. Maybe they are capable of understanding and signing a power of attorney, for example. So if that's the case, I would find out why the doctor's reticent. But you can, if the doctor's just uncomfortable, doesn't want to get involved in court proceedings, or has some reason that, doesn't make sense to you, you can go to any physician who is licensed in Texas. It does need to be a MD, a physician, an MD, or a DO. It can't be a physician's assistant. It can't be a nurse practitioner, but you could go to a different doctor. So my daughter, for example, has many specialists. I could ask her neurologist to complete this, but I could also ask her primary care doctor to complete it. And so you don't have to go with a set doctor, but it does need to be someone who knows your child well enough to fill out this form. Now, in some cases, there are doctors who will do an evaluation and take a few hours to get to know your child, and they will fill out this form even though they're just meeting your child. But usually it's ideal to use your own, the doctor that you're used to seeing. Did that answer the question, Allison?
Yes, for sure. And how often does this document need to be completed?
It just gets completed at the outset of the case, and this will be the main medical evidence that will be used in the case. This will be given to an attorney ad litem who will be court ordered to represent your child, and the attorney ad litem will review this medical evidence. You can add additional medical evidence as well. And I am aware that in some counties, they might vary a little bit on this, but this really is the form that is used overwhelmingly in nearly every county. So this is the safest form to use, and many counties will require this particular medical examination form to be completed. And I say that because sometimes I'll have parents come to me and say, hey, the doctor wrote this note. It says my child's incapacitated, needs a guardian, use this. In my particular county, and most of the ones in this area, it's not enough. We need this particular CME form completed. Okay, let's keep going. So that is the certificate of medical examination. And as I mentioned, based on how the doctor completes this form, you will be asking for either a full guardianship or that partial guardianship. So again, it is possible for your child to retain some rights, but you don't want to just say, oh, it hurts my heart to have them lose these rights. I want my daughter to keep the right to get married, the right to choose where she lives, and the right to drive, but I want to be the guardian. It might be you go to court and the judge will say, this makes no sense. How can your daughter choose where she's living and get married and do all these other things? Are you sure she can't, make her own medical decisions as well. But in some situations, we do a very limited guardianship. So it needs to be very case specific. It needs to be tailored to the needs and capabilities of your own child. There are two types of guardianship in Texas. We have guardianship of the person and guardianship of the estate. Now, guardianship of the estate is managing money. Guardianship of the person, that is making the medical decisions, educational decisions, choosing where someone lives. It covers everything else other than money management. And in many cases, we can avoid a guardianship of the estate. There was some guardianship reform done in Texas a few years ago that makes it mandatory before a guardian is appointed that we all look at alternatives to see if there are alternatives out there to avoid this guardianship altogether. So when we go to court, we actually will have to talk to the judge about the fact that we thought about alternatives, we considered alternatives, we put all the supports and services in place that we could, but we still need a guardianship. So to better understand these alternatives, let's go through some of them. Guardian of the person, again, this is a guardian who's making medical decisions, choosing where someone lives. Some of the alternatives, ways to avoid this guardianship, would be having your child sign a medical power of attorney, having them sign a durable power of attorney, having them sign a supported decision-making agreement, a declaration for mental health treatment. These types of alternatives require a high enough level of capacity that the person signing the document knows what they're signing. So let me break this down. If we go to medical power of attorney first, a medical power of attorney, that is where the person signing appoints somebody to step in and make medical decisions for him or her if they can no longer make their own decisions. And that's a determination that is made by the doctor. So I should have a medical power of attorney. My college kid should have a medical power of attorney. My husband, we should all have medical powers of attorney. And if your child with disabilities has enough understanding to what that form would mean and can read it and has capacity to understand what they're signing, a high enough IQ score and does well enough in reading that they could comprehend it, then they could also sign a medical power of attorney. So using my daughter as an example, if she has enough capacity to sign this, she can name me as her medical power of attorney agent. And if I'm not available, her dad could be the backup or one of her siblings. And it's up to the person signing it to decide who the agent's going to be. So I can't go fill out this form for my daughter. She has to be the one to sign it. And then she still makes her own medical decisions until a doctor says she no longer has capacity. And that's when I step in and make that decision. I will say on medical issues, for a lot of our kids, they need a little more support. And that's where a supported decision-making agreement comes up a lot. And so my daughter maybe would appoint me as her medical power of attorney agent, but she could also complete a supported decision-making agreement where she names me as her supporter who can go to the doctor's appointments and help communicate for her and help explain things to her, help her make decisions, but she still has the ultimate right to decide for herself. That's it. So that's sort of the medical angle. And then the durable power of attorney, if you want to jump to that screen, Allison, the durable power of attorney, that would be other types of decisions, financial decisions. This type of power of attorney would let me go and open a bank account for my daughter or help manage her funds, sign her name on a lease agreement. So it's covering other decisions other than medical.
You're breaking up on our end. You're frozen.
Oh dear. Can you hear me now?
We can hear you.
Okay, I'll keep going. A durable power of attorney, this one, you can decide when you sign this power of attorney if you want it to be effective immediately, the moment that you sign it, or only if a doctor says that you are now incapacitated. So again, going back to my daughter, if she has enough capacity to sign this, she can appoint me to be her immediate power of attorney agent to be able to sign documents for her, make decisions for her, or she could decide to let me only step in if a doctor says she's incapacitated. So those are the two types of powers of attorney, the main ones that we use. Let me elaborate a little more on supported decision-making agreements. If you could go to that slide. A supported decision-making agreement, this is the form that lets someone with disabilities appoint somebody to help them, even though the person with disabilities wants to keep their own rights to make decisions. So again, well, let me go back. The theory for these supported decision-making agreements is that someone with disabilities might very well be able to make their own decisions. They just need some practice. They need a little help. And I think that applies to all of us. You know, as we reach adulthood, we all need a little bit of help and support, but especially our kids with disabilities. And so the theory is that we want to let our kids practice making decisions, but have them appoint someone who is legally authorized to go to all the meetings, have a voice to explain things. But again, this document does not give a parent the right to step in and make a decision. It only gives the parent the right to give advice and counsel and help communicate the situation. Allison, are there any questions on these supported decision-making agreements?
Well, we have a question on, can guardianship of the person do both money management and all other decisions like medical and education, etc.? Does guardianship of the estate do both money management and other decisions?
Yeah, great question. Guardianship of the person is not going to give you the right to manage money. Now, we're going to see that there may be other ways that you can manage money for your child other than becoming a guardian of the estate. But if you're a guardian of the person only, that does not give you authority to manage money as a guardian. A guardian of the estate, that does not give you authority to make medical decisions and decide where your child lives. So I would submit that for most people on this call, if you need a guardianship, you probably are going to need guardianship of the person. And oftentimes you can find an alternative to avoid the need for a guardianship of the estate. And we'll get into that next. But yeah, that's a great question. Guardian of the estate is the only way you can manage the money as a guardian. So you have to find
another question, Alison. How often this document, the guardianship of the person, needs to be updated? So every year right after you got it?
Yes, so it's a really big deal, a big proceeding to go to court and get appointed as a guardian. You need an attorney involved in that proceeding. An attorney ad litem will be appointed to represent your child. And once that court hearing happens and you're appointed as a guardian, you do have to do a follow-up every year, but it's a very simple report for a guardianship of the person. It's an annual report. You don't need a lawyer to help you fill it out. It's pretty straightforward. And you're just letting the court know what the latest is with your child, or where they're living, how's their health. And as long as you do that report every single year, you'll get renewed guardianship letters. The guardianship letters, those are the certificates that state that you have the right to be the guardian. Okay. So when you're first appointed, that guardianship letter is going to have an expiration date. Well, it's always going to have an expiration date, but when you're first appointed, it's going to have an expiration date of 16 months. And the reason is because a year later, that's when you're supposed to do the report. So the court gives you a couple months to get your report in, and they want a couple months to get letters out to you, which is why they let your letters continue for 16 months.
Awesome. Thank you.
Yeah, let's go back to guardianship of the estate, less restrictive alternatives. We touched on that. So obviously, one less restrictive alternative to having a guardianship of the estate would be these supported decision-making agreements that we were talking about. These are really simple documents, and it's easier for our kids to understand these documents than a power of attorney. Although I don't want to be misunderstood, I very rarely would recommend someone rely only on a supported decision-making agreement. I think it's just too risky, because there may come a time that a decision needs to be made, and having a supported decision-making agreement only is putting you at risk of needing an emergency guardianship or having lots of problems. But supported decision-making agreements, the questions are very straightforward, and you can just say, I would like someone to help me manage my money. It'll say managing my money and my property, and the person signing the supported decision-making agreement can just check yes. So very simple. The other power of attorney, which we've already mentioned, is this durable power of attorney. This would give you the right to get in and handle money, open up a bank account, move funds from a bank account. And so you see this a lot of times. Elderly individuals, you know, they have a power of attorney appointed, and maybe in their later years when they're diagnosed with dementia or Alzheimer's or a serious terminal condition or something, a power of attorney will step in and start paying the bills and managing things. So these are really important documents for all of us. Another alternative, and this is a big one for kids like ours, a Social Security representative payee. This is a fiduciary appointment for somebody to manage Social Security funds. So it's not all kinds of funds. It's only money that is paid out by the Social Security Administration. So it could be an SSI payment, it could be an SSDI payment, but it gives me, I am my daughter's representative payee right now. So with that authority, I can go open up a bank account, and my name's on the account, and so is my daughter's. I can also visit with the Social Security Administration about her case. I get all the same mail that she gets. Excuse me. So becoming a representative payee in a lot of cases is all we need to do to manage our children's money, because for a lot of us, our kids aren't bringing in other money. And so a lot of times this is enough. We can avoid guardianship of the estate just by becoming the representative payee and managing that income, because that may be the only income that is coming into the household. You'll see on the slide here that you'll note that the Social Security Administration does not accept powers of attorney. So you could have a power of attorney and Social Security would say, well, thank you, that's really nice. We don't take that. We use representative payees. They will obviously honor a guardianship, but they will still make you become a representative payee in addition to a guardian. So on the screen there, you can see different ways to get that taken care of. It's a really simple process. If your child can't manage money, the Social Security Administration will usually know that, and it's not difficult to get someone appointed as a representative payee.
So what about when the Social Security Administration says that if you don't have guardianship, that you can't be a representative payee? Do you have an answer for that? Because, you know, everybody gets different people when they call, and not everybody's always trained. But I've definitely heard of people being told that. So what do you say about that?
I've heard that too. And I would just say that's just not right. Well, I know that from a personal standpoint. I'm actually not the guardian of my daughter, and I am her representative payee. It absolutely works. I've seen it work over and over. You can be a guardian and a representative payee, but you do not have to be the guardian to be the representative payee. Now, what could be happening, again, this is going to be an individual case. If your child clearly has no capacity, it may be that the Social Security Administration is trying to convince you to do a guardianship, but you do not have to be a guardian to manage funds as a representative payee. Absolutely not. So a lot of times it is somebody new. I mean, when you think about all the turnover that happens at the Social Security Administration, you know, cases that we deal with all the time are actually not as common for those workers. So sometimes the caseworkers just need more experience to understand. Great question. Anything else before we move on?
There was just one more question, and I actually believe it was more towards the last slide of about a combination of both.
Okay.
They're basically asking is, you know, where is there a combination of both? And then the only other question that we had is about if there is a such thing as if guardianship could be split between.
Okay, Allison, you cut out.
Right now we share joint custody, so.
Okay, got it. So
can guardianship be?
Okay, you're cutting out a little bit. I don't know if it's my end, but I think I've got that question. So first of all, guardianship, you can have co-guardians. That is absolutely possible, but you need to be a married couple, or you could be a divorced couple where you're both the parents of the person under a guardianship. So in other words, if there's a divorce situation, the biological parent could be a co-guardian with a step parent, or the biological parent could be a co-guardian with the other biological parent, even though you're divorced. But you cannot have a co-guardian with a mother and a sibling of the person under guardianship. It needs to be a marriage other than those limited circumstances. As far as, using alternatives in combination? Absolutely. And that's a really good point. Most of the time we will have lots of different levels of alternatives in place. So for example, I'm the representative payee for my daughter, but I'm also an agent under a power of attorney. I'm also a supported decision-making agreement appointee. And my daughter also has a special needs trust. So let's talk a little bit about the trust, because this is a really important alternative. We mentioned that the guardianship of the estate, that's where the guardian is managing money for the person who doesn't have the capacity to manage. What we want to make sure we do is we want to make sure that all the money that is going to go for the benefit of our children has some other way to be managed other than through a guardianship. So again, the representative payee is managing the income that's coming in from the Social Security Administration. But when I die, I want to leave my daughter some funds. I don't want her living on just very limited income that she gets because of her disability payments. I want to have an extra source of funds for her to tap into so that she can live in a nicer place, go on trips, or do the things she loves to do. And that's where I can leave funds to a special needs trust and appoint a trustee to manage those funds. And all of us on this call should know about special needs trust. So I agree. I urge you, if you're not familiar with that, to do a little research into that. I know Allison has a lot of videos and information on special needs trust, but just briefly, a special needs trust is a certain kind of trust set up for someone with disabilities, someone with special needs, and a trustee is the person or the corporation that is appointed to manage the funds for the benefit of the person with disabilities. And if you have a proper special needs trust, all the money in that account will not be considered money belonging to our children. And that's really important because for a lot of government benefits that our kids want to use, Medicaid waiver programs, SSI, all Medicaid type programs, our kids can only have very limited income and assets. And so by having a special needs trust, our kids can continue to qualify for these government programs, and they can also have somebody who is managing extra funds for them. So again, going back to my daughter's case, if my daughter needs a new computer, the trustee can pay for a new computer. If she wants to go on vacation with her brother, the trustee could pay for her ticket to go somewhere, or her food, or whatever she needs. And so these special needs trusts are important. Oh yes, this slide that Allison just pulled up, just briefly, it is important to understand that there's a first party trust that is funded with assets that already belong to the beneficiary, and a third party trust that's funded with assets belonging to other people. And the big difference to remember is a first party trust has a Medicaid payback on it. That means if my daughter has a first party trust, when she dies, Medicaid gets reimbursed from the funds that are remaining in her trust. That's different than a third party trust. When she dies there, we look at the trust document to see where all the money is going to go, any leftover money to her siblings. But it could be charity or whoever you want. So again, this is just a really quick point, but special needs trusts do serve as alternatives to guardianship, because now we have a trustee that can manage money. We don't need a guardian of the estate to manage it. Okay, I'm going to keep going unless someone interrupts me. Next slide here is, how long does the guardianship process take? It depends on the county where you are, but I would say on average 2 to 4 months. It can take up to 6 months. COVID has thrown all kinds of courts for a loop, but on average, I'd say 2 to 4 months. You could file it as early as 6 months before your child turns 18, but you're not going to be able to have the court hearing appointing a guardian until the child is now an adult, so until their 18th birthday. And that makes sense, because at the hearing, the judge is determining that this person is an incapacitated adult. So they need to be at least 18 before you have that hearing. It is possible to have a temporary guardianship. This is when there's a true emergency, and I run into these a lot. Say you have a child in the hospital, and this has happened a lot lately with COVID. There needs to be some pretty significant medical decisions made. and there's nobody appointed to make that decision, and we have an emergency situation, we can go to the court and say, we can't wait for the normal 2 to 4 month process. We need it now. And we get that hearing done within a couple of weeks. We get someone appointed, and then that's a temporary guardianship that lasts a couple of months. And then we need to go back and convert that to a permanent guardianship. And so, but it is possible to get a temporary, but there's got to be a really good reason for it. It needs to be life or health, or, you know, you can have emergency guardianships if someone's stealing all of the money from the grandparent, but there's got to be a real good reason. Let's just kind of talk through the process. We've already mentioned one of the first steps is to get that physician's form completed. And then you file that guardianship application. When you file it, it has to be filed within 120 days of a date that the doctor writes on the CME that when they last examined your child. So if someone examined my child in April, then it says right on the form, this is the last time I examined this proposed ward, then we've got to have the guardianship on file within 4 months of that date. I already mentioned you can file it as early as 6 months before the 18th birthday. After the guardianship application is filed, then the person who's going to be under the guardianship, again, we call that person a proposed ward. It's not a great term, but that's what we use. They will actually be served by a sheriff. So a sheriff will come and deliver your child a copy of the guardianship application. Even though your child won't understand what it is, in many cases, it has to be done by law. And it makes more sense if you think that most guardianships in Texas are for elderly people, people who lose capacity in their later years. And so we want a system in place to protect people who might have a bunch of money in the bank. We don't want someone to just swoop in and become guardian and take over their bank accounts. So you see there's a lot of protections in place because of that. So besides getting served, there are family members that need to be notified of this guardianship. So parents need to be notified, and siblings need to be notified, and children, which isn't common in the context we're talking about, but they would also need to be notified. And parents, some people need to be served, and some people can just get mail, and a lot of people can sign a waiver. The person under the guardianship can't sign a waiver, but siblings can sign waivers saying, I know about this guardianship, it's fine, move on without me. The next thing that needs to happen is the person or people who are going to be guardians, they will need to complete a background check and register with an organization called Judicial Branch Certification Commission, JBCC. And they will run a criminal background check on that person and make sure that whoever's applying is qualified to serve. So there's going to be an order of priority. Obviously, parents are going to be up at the top of the list, spouses are at the top of the list, and then we move out to siblings, and it makes sense. It's the order you would expect. But someone cannot serve as a guardian if they have a pretty concerning criminal background. If you have a felony, it is very difficult to serve as a guardian. You're pretty much disqualified. There are some rare exceptions. If you don't have felony convictions, but you have other types of criminal history that are pretty concerning, you may not be appointed as a guardian. And something that we'd be looking for is some kind of sexual offense, child pornography, maybe a history of DUIs that is recent and seems to be a little bit risky. So it's sort of the common sense, is this person going to present a risk to the proposed ward? And if so, then the judge can say, no, you're not the right guardian. But assuming you have a clean criminal history, you just need to live in Texas or have an agent appointed to represent you. And you can, have this criminal background check done, and you should be fine. You also will need to watch a training presentation online. It takes maybe 45 minutes, an hour at the most. And you get a certificate saying that you watched it, and it's a training on what you need to do to be a guardian in Texas. We already mentioned co-guardians can be appointed if they're married, but you don't have to be. You could just do a single guardian, a sole guardian. If you do co-guardians, then when one of the guardians passes away, the other guardian continues. Okay. Moving on, I've already mentioned that. Oh, can you go back to that last slide? I said moving on and confused everyone. We said that there would be an attorney ad litem who would be appointed, and that is mandatory in Texas. Even if your child doesn't understand what that attorney is going to say. That attorney ad litem has the responsibility to make sure your child's rights are protected. And one of the main things that attorney ad litem is going to be looking at is, do we really need a guardianship? Could we do something less restrictive before we take away rights? Because remember, a typical guardianship, a full guardianship, will remove your child's right to vote, to get married, to make their own medical decisions, to choose where they live. And in many cases, that's perfectly appropriate. It's what we need to do to protect our kids. But in other situations, we might not want to remove all those rights. So that's what the attorney ad litem is looking at. In statutory probate courts, we have court investigators who often are asked to file reports. And so in my county, I can't move forward till my court investigator has called or visited the proposed ward or their families and filed a report. Not all counties have that. And then we have the court hearing. And then after the hearing, we have a bond and an oath that are signed. The oath is a very simple swearing in that you'll be a good guardian. The bond is required in Texas. And depending on the county where you're in, it could be a personal bond where you're just signing paperwork saying, I know I'm on the hook for a certain amount of dollars if I skip town and I'm not a good guardian. In most counties, you'll be required to do a cash bond or a corporate bond. In most of the counties in my area, we get a $100 bond that is renewed every year, or we can do a lifetime bond that we pay $375 one time for. But everybody's got to have some kind of bond. I see a lot of questions coming up, so I'll stop talking for a minute.
We have questions, Allison.
Okay, go ahead.
If someone has guardianship of a person, what needs to be done to get guardianship of a state since he is disabled from day one?
If you only have guardianship of the person, it might be you don't need guardianship of the estate. It might be that you can just manage the money as a representative payee and by having other funds go to a special needs trust. Of course, powers of attorney are not going to be applicable in that case because obviously there's pretty significant incapacity. But if there's a reason why you really need the guardianship of the estate, you can file an application and go to court and explain why you need some extra authority to manage some funds that have come in. Again, usually we find an alternative. We can also ask the court to create what's called a management trust. You know, if there's like an inheritance or something that needs to be managed. So I would talk to the lawyer to see if you really need a guardianship of the estate. If you need it, you just go back to court and get it.
Got it. During the guardianship hearing, is the person you want appointed as the guardian requires to be in the hearing? Example, the person I would want to appoint lives in Washington State and we are in Indiana.
Okay, yes, the person who wants to be the guardian needs to attend. Now, right now, we have attendance by Zoom, and there are a lot of proposals for that to continue. So that is we're just gonna all have to wait and see how that works out. Someone can be appointed as a guardian, even if they live in another state, but they need a resident agent who lives in Texas. So typically that's the lawyer. So I'm a resident agent for several guardians so that if anything happens, I get notice and I can track them down. But it is possible to be a guardian in another state, but you do need to be in attendance at the hearing, whether it's in person or you could attend by Zoom. Is going to be county dependent, and honestly, we just have to see how the law comes down on all these Zoom hearings if we're going to be able to continue them or not.
Got it. Thank you for that. In guardianship, can we place succession in the will, or can it be part of the guardianship letter out also?
Yeah, that's another great question. Anyone who is under a guardianship, or anyone who is a guardian, I should say, or who thinks that a guardianship may be needed for their children, you definitely want a will that says who the guardian should be if you're not alive, because the judge is going to always ask when you die, hey, did mom have a will? Who did she think is the right guardian? And the person you name is going to be given priority over everyone else. Now, it's ultimately the judge's decision. That person who you've named in the will is still going to have to go to court. They're still going to have to watch that training presentation. They're still going to have a criminal background check. They're going to have to get their own bond, and they're going to have to be appointed by the judge. So it still involves a court proceeding, but it's not going to be the big court proceeding where we determine incapacity, because we already have that decision done. You know, once the typical guardianship, it just means that the guardianship is for the lifetime of the person who needs it. But let me think, I got distracted. So yes, you should have it in your will. And even if you're not a guardian now, but you think there's a chance your child will need a guardianship, put it in your will. There's a separate document called a designation of guardian for my children. You could do it that way as well. It cannot be part of the actual guardianship letter, but you can make sure the other documents are in place so the court will know who you want to be the guardian.
Allison, we got a question here. What happens if the previous guardian dies and there was no successor guardian designated? Will the entire process need to start again? Does the person become a ward of the state? What happens?
Yeah, that's another great question. You don't have to do a whole new medical determination of incapacity, because again, the judge has already said this person is permanently incapacitated unless evidence comes in that something has changed. So if the guardian has died and the court has got to appoint somebody else to be a guardian, the court is always going to look for family members first. What will probably happen is the court will appoint what's called a guardian ad litem, a temporary guardian for the case, to go out and find some family members, try to see if there's somebody who is willing to step in. And the closest family members are going to have priority if more than one person wants to do it. And the judge will decide who the best guardian is. If there really is no family member out there who can step in and become the successor guardian, then there are programs in different counties where a county will appoint somebody. There are also professional guardians where they will step in and get to know the person under guardianship, and they get paid a very, very small amount, but it's a really great service opportunity for a lot of people who love to do this. But family members are always going to be preferable, or friends, or someone who knows the person. Judge is always going to want to do that first.
What about an example of a family, a married couple, who they themselves tend to be intermittently severely ill themselves, and but one of them had a felony a long time ago in the past? If they had a felony a long time ago, like, you know, are they definitely out for guardianship forever, or is there a 10-year statutory period? How does that work?
There's not a set period, and it's really going to be up to the judge. I mean, if it was a long time ago and you can show, you know, what the situation was and that there's a probation that was completed, and, you know, it is possible that the judge will say, we're going to allow this. But a lot of times the judge will say, well, if there's someone else, we're just going to use this other person for now. So there's no set rule, but there is not a 10-year statute of limitations. I can tell you, I have spent a lot of times in a lot of hearings having to address stupid things that people did, you know, 30 years ago, 40 years ago. A lot of us do dumb things when we're 18, 19, 20. And if it's on your record, it's going to come up. Now, does it prevent most people from becoming guardians? No, but if it is something where you serve time or have a felony conviction, it is going to be something serious that could possibly disqualify you from serving.
We have another one. Can you do a partial guardianship to have a say where the child lives and finances only?
Yes, you can have limited guardianships, and you can indicate on your application which rights you want to have taken away from your child and what powers granted to the guardian. But remember, you've got to have a doctor who's in agreement. So if you want to be, the example was, say, determining where this person lives. If you feel like you need to have the right to determine where someone lives, but your child is capable of making their own medical decisions and voting or whatever else, the doctor's got to agree with you on that form, because the judges are going to give different deference to the doctor. And you've got to have a good reason for it. But it happens. I've done it many times. I mean, I have a situation that I'm in now where there really is a good reason that this child may be swayed to go live somewhere that he shouldn't be living. And we are doing a very limited guardianship to, you know, provide some protection from some, enticements to go to live in the wrong place. So it really is going to be case specific. But again, you've got to have a story that makes sense. Why is it that your child cannot make this decision and needs to have that right removed, but they could make these other decisions? You don't get to just pick willy-nilly. It has to make sense in your child's case.
We've got another one. In some situations, the family law court continues conservatorship for the disabled kid beyond 18 years old. How does this differ from guardianship rights? Are both the conservatorship and the guardianship rights the same?
Yeah, that's a really great question, and it's a confusing area of the law. So child support can be indefinite for somebody who has significant disabilities. And so a lot of times there will be a family court order that says that this person is found to be a disabled adult child, and they have child support that is indefinite for the rest of their life. And there may be specific orders written in as far as the custody and visitation. If that was done after the child turned 18, a lot of courts will say that's a less restrictive alternative to a guardianship, and let's just use the family court order. However, if it is a typical family court order where there's no finding of incapacity beyond the age of 18, then the guardianship will be the right place to have that determination of incapacity. The child support, what happens in some cases is we have lifetime child support being handled in the family court, and we have a guardianship being handled in the probate court. It is possible to consolidate those cases. So sometimes if we do have lifetime child support, but we need a guardianship, we move the child support case into the probate court and make them one big case in the probate court. But again, a probate court is the court with the jurisdiction to appoint a guardian. A family court cannot appoint a guardian. It has to be done in the probate courts.
In the event of the successor guardian, does the bond transfer, or is it refunded? What happens?
No, your bond is, it's going to be dependent on what your bond is, but the bond is probably not coming back to you. I have seen it come back a couple of rare occasions, but it's a bond, it's insurance that you'll be a good guardian. So it's like you're paying your premiums, your insurance. But when the new person is appointed as a successor guardian, they will need to get their own bond. So again, in this area, typically we see a one-time fee bond done where both parents can be bonded for $375 over their lifetimes. But when that second parent dies, the sibling or whoever the new guardian is has to go get a new bond themselves and do all those other steps to show that they qualify. Great question.
What about the medical, the CME? What if you have a psychiatrist and another doctor that disagree with each other? One thinks yes, one thinks no. You just go with the one that thinks yes. Or what
yeah, I mean, you would hope that there would be some consistency, but if there's really inconsistency, then you as a parent, you're going to have to do some soul searching and some real deep thinking, what is right for my child? And then use the medical evidence that supports what you feel is right for your child, whether it's no guardianship or limited guardianship or a full guardianship. You've got to make that determination yourself, but you need the medical evidence to back it up. So you're not required to turn in every single CME that you get, but ideally you don't have big differences, but I know it can happen sometimes. And if there's somebody who contests this, say it's a divorce situation and one parent thinks there needs to be a guardianship and the other parent thinks there does not need to be a guardianship. That's where we see this. One doctor might be saying no guardianship and another doctor might be saying yes. And, unfortunately, a lot of times that leads to litigation and mediation and more expense trying to sort it out.
Let's talk about the less restrictive alternative with power of attorney, healthcare power of attorney, and supported decision-making. In the example where a family may have a kid that is oppositional or adversarial, and basically they retain the right to revoke that at any time. So talk about that, because we've seen a lot of that in the last 2 years.
Okay, yeah, that's a really good point. So if you are saying my child has the intellectual capacity to understand what they're signing and they can execute a valid power of attorney, it's going to be very difficult for you to turn around and say, if your child revokes it, that they didn't know what they were doing. So in other words, if my daughter signs a power of attorney appointing me as her agent, but then she gets a boyfriend and she says, you know what, Mom, I'd rather have my boyfriend be my agent. It's going to be hard for me to say, oh, she doesn't have capacity. She doesn't know what she's doing. But in some cases, the actions are so severe, you know, someone who's making such clearly poor decisions, we can go to court and say, Your Honor, we tried powers of attorney, and let me tell you what happened. This happened and that happened, or, you know, this person kept revoking it and was giving powers of attorney to a stranger and went and did this and that. Remember, a power of attorney does not keep your child from making their own decisions. So just because I have power of attorney does not keep my daughter from signing documents, from running off and getting married or doing what she wants. So again, if there's a history of really poor decisions, we can go to the judge and say, even though there's a higher intellectual intellectual ability here, we've got a history of terrible decisions and we need to protect this person, and we get medical support for that, and we can move forward with the guardianship. Okay.
We have
go ahead.
Bond amount full payment or a small amount for lifetime bond.
Can you ask that again? You cut out there.
Is the bond amount full payment or a small amount for lifetime bond?
Okay, so it depends on your county. I'm in San Antonio, and in the counties all in my area, almost all courts will allow either a bond that you renew every year, and that typically is about $100. For $100, you get $11,000 worth of insurance. So the judge will say, how much bond insurance do you need? And out here, we can typically renew it $100 every year, or whatever the judge sets. Maybe it's just pay the court $100 one time. But we have an alternative because so many parents don't want to keep paying the $100 every year. There is an option in most of these counties out here where we can do a one-time fee for $375. You pay it all up front. You show the judge that your bond is completed, and then you don't need to keep paying that ever again as long as you're living. But then the successor guardian has to get their own bond. I hope that answered that. I see a question about renewing the guardianship, revisiting, and we have it on the screen, so let me touch on that. Your guardianship letters, as I mentioned before, they do expire in 16 months after you're appointed, and they're going to expire every year. They're going to expire again, and so you need to do an annual report once a year. So once you're appointed, you say, okay, I became guardian on, April 25th. That means next April 25th, I got to start working on my report. It's a super simple report, just filling out a few questions on some forms that are, some courts have their own forms, but we can provide forms to you. You turn that in. It usually costs about $10 to file it, $12 in some counties. And then the court gets a couple months to read it and have the judge sign off on it, and they send new letters out to you. That's for the report. If you have a guardianship of the estate, you actually have to do an accounting, and that does require a lawyer in almost every county. There are a few counties where I don't know how you get away with it, but you don't need a lawyer. But in most counties, you're going to need to hire an attorney to do that guardianship of the estate accounting. So you're looking at attorney's fees forevermore, which is why we try to avoid guardianship of the estate where we can, because we don't want to set you up for lawyers' fees every single year. You also have to show the court that your bond is current. And in some counties, there's going to be a court monitor or visitor who comes in and files reports. But the main thing on you is to make sure your reporting is done timely and your accounting if you're a guardianship of the estate, and you'll get your new letters.
So how do you determine the probate court for guardianship? Is it the county that the ward resides in, regardless of where child custody took place?
Yes. And you do your guardianship where the child is living. If it's a guardianship of the estate, then it's a little more complicated, and it could be the location of some of the assets. But, generally speaking, and for purposes of this call, just plan on wherever your child is living, that's the court you want to go to. And I see here the next question, can guardianship be modified or terminated? Yes, it can. If your child is under a guardianship and then later on you think this guardianship is restricting rights that we don't need to restrict. My child is doing so much better. This is more common in the mental health world than it would be when there's a guardianship because of a developmental disability. But whatever the reason is, if there's a change in capacity level, you can go back to court and say, I would like my child to have these certain rights restored, or I would like the guardianship completely terminated and have all of the rights restored. To do that is not an easy thing to do. So you're going to have to hire a lawyer again. You're going to have to go get medical evidence to support what you're asking for and go back to court. An attorney ad litem is probably going to be appointed, so it's not going to be cheap. But I'll give you an example. Say if my daughter had a guardianship and she did not have the right to get married, but later on I really wanted her to be able to marry somebody she'd fallen in love with, I could go back to the judge and say, Judge, we really want her to get married. And the judge would, you know, probably run a criminal background check on the person she wants to marry, would talk to her, talk to us about the financial implications, because there would be, and then could restore that right. So it is possible. Anything else? I know we just whipped through some of those last slides.
We did. We're out of time for today. But what I wanted to do is I wanted you to share. I know you're in San Antonio. Can you share the counties that you cover? Because I know we've got people all over the state that are attending this webinar today. Tell us the counties that you cover.
So I cover the counties that are within 2 hours of me. If I do go to some counties that are further out, but the price will be higher. So I'm happy to talk to anyone. What I typically tell people, if you're 4 or 5 hours away, I'm going to charge you a much higher fee than I would normally charge because of the time to travel. And a lot of times you can find somebody local that will be able to do this service cheaper. But I'm happy to visit with anybody and just kind of give you some tips and then at least tell you what I would charge to cover your county. So I've covered counties 5-6 hours away from San Antonio, but that's unusual. I'm typically within a couple of hours of San Antonio.
And we're happy to make referrals for other places throughout the state if you're not anywhere near that area. Last thing, and we've got to go. The burning question always is if I'm planning financially for this, how much can I expect to spend on guardianship? Give us a range. We know if it's contested, everything's more. But give us a range on what people could expect to spend on a guardianship.
I think it's going to be dependent on your county, but I would say unless you are living below the poverty line and can fill out some forms to get some court costs waived or qualify for some kind of service in that area, you're looking at least $3,000, most likely more, it'd be $4,000 and up to get everything done. Now that's not the attorney's fees, but the whole thing besides my attorney's fees, there's going to be about $1,000 in court costs and paying an attorney ad litem. So typically in my area, you're looking at least $3,500, $4,000, $4,500, and I think it goes up from there.
Yeah, I agree with that. And just in case anybody's on here from Galveston County, you live in Galveston County, they have a grant in their county. And so basically you can get guardianship for free under this county grant that they've got going on. So just be aware of that. And we have contact information for the Galveston folks. You got to live there. You can't just try to go there and get the free one. But anyway, yeah, I just wanted to mention that. So Allison, thank you so much for partnering with us again today. Thank you, Veronica. And we will certainly, we're going to put out a recording of today's slides. And so you'll have that for your records and all of the contact information for Allison, myself, Veronica. And so you'll get that email either later today or tomorrow. And it's certainly been a pleasure to be back with you all today. Thanks so much, everyone.
Thank you so much, everybody.
Thanks,
Bye-bye, Allison.
Bye now.
Bye.
Thank you. See you later.
Bye, Allison. Thank